thanks for your attention to this. I love the Senate. I love the fact that we pause, at least on third readings, at least usually, to think about, listen, actually process what's going on. And as I listen to the conversation and think back to the second reading debate, which moved very fast with lots of amendments yesterday, and consider what I'm hearing today, it occurs to me with great clarity we are having what is classically called an AM-FM conversation. We're talking right past each other. And you don't have to go any further than the short title of the policy to understand what's going on. The short title of House Bill 25-1312 is the Kelly Loving Act. Kelly Loving was an heroic 40-year-old trans woman who put herself in between her friends and fire. 40-year-old who sacrificed her life for the benefit of her friends. That is the call out of this particular act. And the arguments that you have heard strenuously over and over and over again from the non-sponsorship side are all about children. Not 40-year-olds, not even 18-year-olds, but children still in the protection of the circumstance that we call custody. It's that big of a deal. We use the word custody to describe the relationship and responsibility between parents and their children. So my comments will continue in that vein. They are the reason of my opposition. I would say the bill as presented was extreme in the extremis. It was beyond the beyond. And now it's been reduced and reduced and reduced with 3 major amendments and a few smaller amendments to just be what I will describe as suboptimal, the word we typically use, although it's a philosophical word and doesn't therefore have the precision that I wish it did, bad policy. While intended to protect transgender individuals, sponsors are thinking Kelly Loving, 40-year-old hero, this bill introduces significant risks of government intrusion into the sacred, that's a considered word for me, parent-child relationship. My concerns focus on the bill's school policies, their conflict with existing Colorado law, and the enforcement mechanisms involving the Colorado Civil Rights Commission and Division, which threaten in a critically important way, even now as amended, parental rights and draw the state into personal family matters. Additionally, the bill's redefinition of speech related to chosen names as potentially discriminatory creates new threats to free speech. We heard a very eloquent speech about founding documents and freedoms that are inherent in this experiment that is America. This bill, in my opinion, considered opinion with logical support, not just an emotional flyer, is a risk to freedom of speech and a potential threat, coercive, word removed from the bill, but I would argue still inherent in the policy, coercive, mandated speech, antithetical to who we are as Americans. Section 6 of House Bill 1312, and to be clear, colleagues, I'm working from the revised as of last night, with all of the amendments in it to today. So the bill that we had, the pre-amended version May 5, has now been overcome in the last several hours by the revised version of House Bill 251312. That's the one I'm referring to. Section 6 of the revised bill, codified as CRS 22-1-145.5, mandates that if a local education provider adopts a policy on chosen names, it must be inclusive of all reasons, whatever reason you want. Make it up out of thin air if you want, or have a considered deep purpose. But the policy says all reasons. That can come out of thin air. And I'm not saying that will always be the case, but that's what we're putting into the law. A student might adopt a name different from their legal name. It goes back to the Pokemon name we were just hearing about a few moments ago. This requirement conflicts with settled Colorado law. What we have said, and we have year after year allowed to remain in the law books and not changed. Here's the considered Colorado law. I refer you to 1322-107. Parents have a fundamental right and responsibility to make decisions concerning the care, custody, and control of their children. The law has long presumed, I'm reading from the statute book here, and it's referring to preceding law. The law has long presumed that parents act in the best interest of their children. Parents make conscious choices every day on behalf of their children concerning the risks and benefits of participation in activities that may invoke risk or involve risks. These are proper parental choices on behalf of children that should not be ignored, says the law. So long as the decision is voluntary and informed, that would be the parents being voluntary and informed, the decision should be given the same dignity as regarding schooling, medical treatment, and religious education. That's what the settled law says. We believe parents are important, authoritative, fundamental. Why? Well, it goes back to the word I used to describe the parent-child relationship. Sacred. It has thus always been so. And as I acknowledged on the mic last night, there are situations where it's broken. It doesn't always work that way. But generally, almost always, it does work that way, which is why 1312 is such a policy offense to me. The rights as codified, affirmed in the statute, are fundamental to parents' ability to direct the education, the upbringing, the care of their children. As the bill proposes, by compelling schools to honor a student's chosen name, potentially without, and it has been meted out in behavior, potentially without, frequently without, not always, but frequently without parents' notification or consent, this provision in 1312 risks enabling schools' ability to facilitate a child's social transition in secret, hidden.
Mr. Minority Leader, you have 45 seconds left. Would you like to continue on to your second 10 minutes?
I thought as Minority Leader I got 45 minutes.
Oh, yeah, we changed that.
Fair enough. I will take my second 10 minutes and
Okay.
light a fire under it.
Go for it.
For example, a student might adopt a chosen name tied to gender identity, and parents could remain unaware of these significant changes affecting their child's emotional and psychological well-being. This undermines the trust essential to that sacred parent-child bond. Positioning government, in this case, it's schools, but it's government, by positioning government as intermediaries between parents and children in critical family decisions. Section 7, again, referring to the revised, further compounds these concerns by requiring school dress codes to allow students to choose any option provided without regard to gender. This mandate may clash with parental values or significant cultural beliefs about appropriate attire. Now, that is not so present in this moment in Colorado, but there are other states in this country where there are growing, expanding cultures that are very significantly tied to headwear, to the specifics of what the attire of the children may be. And it's fundamentally important to the family, to the parents, with regard to their beliefs about what appropriate attire is. This bill intrudes into that familial conversation. Parents guiding their children's clothing choices to align with family principles would very likely find themselves at odds with school policies, inviting state intervention to enforce compliance. So now we've got the state, by virtue of the government school, intruding into that familial decision and saying, no, that's not what will be allowed here. This risks sidelining parents from decisions about their child's expression, further eroding their authority. Moving on to sections 8 and 9, again to the revised bill, the current form of the bill, not talking to something that has been wiped away, but it is the law as it would be, passing out of here, headed back to the House for reconsideration. Sections 8 and 9 of the amend the Colorado Anti-Discrimination Act to include chosen name. Chosen name, that's a specific called out quote that's in the law, within the definition of gender expression, and establish the Colorado Anti-Discrimination Act as the framework for addressing related complaints by defining the failure to use an individual's chosen name as a potentially discriminatory act in the public accommodations law, including schools. These provisions empower the CCRD to investigate and adjudicate complaints. We've seen this movie before. When you have a judge, jury, and executioner, things get out of whack. And now we're putting that into this law in enforcement by an advocacy organization. For instance, a parent who uses their child's legal name to maintain consistency or address concerns about rapid identity changes could be reported for failing to use the chosen name, triggering a state investigation. Family has an investigation in the household, potentially. Parents are under investigation because the teacher has said, and they reported it. I mean, that's down the road. It's not in this bill. Don't want to misrepresent that, but you've already heard comments about expansive. We need to go back to the extreme version. I can envision a mandatory reporter law at some point in the future. Schools are already mandatory reporters on abuse. The bill is introduced, opened that door, defined abusive behavior by specific words. This risks escalating personal or familial disagreements into formal legal conflicts, drawing the government into disputes that belong with families. The Commission's involvement could chill open communication between parents and children in the moment when it's most important that those communications be open, helpful, and now you got the government right in the middle of it. By classifying the failure to use a chosen name as a discriminatory act, 1312 redefines speech itself as a form of discrimination. Speech is now discrimination, granting the CCRD unprecedented authority to police language. This new reality threatens the First Amendment. The state could compel the use of chosen names while restricting the use of legal names, even in good faith contexts. For parents, this creates a chilling effect. Again, I'm deeply concerned about the wedge we're driving into that sacred relationship between parent and child. In schools, educators and students may self-censor to avoid complaints, stifling open discourse essential to education. What's my time check? 5 minutes. Oh, good. Then I'll just talk really fast. The CCRD's expanded role also risks inconsistent enforcement. as subjective complaints about name usage hinge on perceived harm rather than clear intent. You can never know what's going on in another person's mind. That's why we don't challenge or question motives here. You can't know. The motives may be pure. This could overwhelm the commission, diverting resources from addressing tangible discrimination and setting a precedent for further speech regulation. So now you got me here defending the commission, saying let's not throw one more thing on their plate that's going to get out of control. Such overreach undermines Colorado's tradition of valuing free expression and risks fracturing the parent-child relationship. The bill's emphasis on chosen names in public forums, this is again still in Section 8, and school policies, that's earlier in the bill in Section 6, creates a framework where the state prioritizes a child's preference over parental input. A chosen name must be used across public entities, if requested, potentially bypassing parental awareness. In schools, this could mean a child's chosen name is adopted in the records, classrooms, and communications without parental knowledge, further straining those family relationships. The intersection of these provisions with the Anti-Discrimination Act amplifies the risk of state overreach. Colleagues, parent-child relationship is the cornerstone of a free society. What we do is nibbling at the edges of things that are not fundamental until we bring a bill like this. And then we say, you know, that fundamental way that it has for millennia worked, we're going to upend that. Again, the AM/FM conversation. I'm not talking about adults. I'm talking about parents and children and what this act will do to the majority of the circumstances, the threat it creates in the majority of the circumstances. 1312, despite its protective intent, creates a system where schools and state agencies become the arbiters of deeply personal family decisions. By mandating inclusive name policies, enforcing gender-neutral dress codes, enlisting the CCRD to police speech, this bill risks transforming schools and courts into arenas where the state overrides parental authority. We must not allow government to intrude into and fracture the trust between parents and children. I urge you to vote no on 1312. Let's preserve the sanctity of the family unit and uphold the rights of Colorado parents to raise their children without fear of state interference. And at the same time, acknowledge Kelly Loving was a hero who threw herself in between her friends and the threat that was coming at them. Thank you, colleagues. Thank you, Madam President.
You're welcome.
Mr. President.
You're welcome.